Recent lawsuits over odors emanating from North Carolina hog farms have resulted in tens of millions of dollars in punitive and compensatory damages. One of the analysts following these cases closely is the former head of the state's regulatory agency that oversees the rules about farm odors, and he has lots and lots of questions. Don Vaart led the Department of Environmental Quality in the McCrory administration. He is now a senior fellow with the Locke Foundation. Don, welcome back to the show.
Thanks for having me.
I thought that there was technology in place that would mitigate odors emanating from hog farms. Am I right or wrong?
Well, not only are there various technologies, there is a regulatory structure to implement those. And to get to your question, about 20 years ago, there was an agreement that at that time Attorney General Mike Easley brokered, where the industry funded research at North Carolina State University to develop cost-effective technologies. And they did that, and they even have a number of different steps, levels of technologies that are available. At the same time, there was a statutory requirement added by the General Assembly to attack odors, and a regulatory scheme came thereafter, authorized by that statute, which was implemented by the Division of Air Quality, and that regulatory scheme is very prescriptive.
And in fact, what would happen, Don, then if a neighbor to a hog farm says, "Hey, there's stuff going on here. I can smell it, and this is such a problem that I need to contact authorities"?
Exactly. What the rule provides is an initial series of requirements that every farm had to implement by mid-1999. But thereafter, if there was a neighbor that was unhappy, they were to complain to the division. And the division actually maintains to this day trained odor inspectors. And that's
incredible.
Possible.
Wow.
It's possible.
I didn't know that expertise existed, but obviously it does.
And they maintain their training for just this purpose. And the purpose is, of course, to respond to complaints and to thereby substantiate what's going on. The rule provides that if those complaints are substantiated, there are a series of steps that the Division of Air Quality will implement to ultimately prevent those odors.
And that gets me to my next question, because listening to you describe this, okay, there is technology and there is a regulatory regime in place that requires that technology and the mitigation of odors, yet we have lawsuits. So what gives?
This is my question. Apparently, and there's no reason why under the common law, a plaintiff can file a nuisance claim. What's surprising to me is that this is going on in a vacuum when we have a regulatory regime. And let's go back again. All the farmers were required to do certain minimal steps to mitigate odor.
So you must comply if you have a hog farm.
There are already requirements that they're having to comply with. For example, they have to ensure that when they spray irrigate, that the spray does not leave their property, for example. And then there are these additional steps. So the question I have is, are we to assume that these folks are in compliance? And if that's the case, did the judge consider that? Or did these complaints never get filed? Or did the division not respond, which I'm sure they would have if they hadn't gotten their complaints? So where are we in this very prescriptive regulatory structure? And what seems to have happened is that the common law suit that proceeded in federal court ignored these steps, and I'm not sure why.
That's the big question. So To whom do we address that question then? Because it seems very serious. And one would think that the hog farmers that are impacted or the attorneys representing those hog farmers would be making that argument, hey, my client complied.
It may well be that the judge, and there have been now 2 judges that have been involved, but the first judge was the one who found all these punitive damages in addition to compensatory damages. And it may very well be that the judge disallowed this information from entering into evidence for reasons unknown. And so on appeal, you're going to see, if that's what happened, you're going to see the representatives of the hog industry bring that up in appeal. So it'll be very interesting to see what happens next. There are still lawsuits going on at the district court level under a different judge, and there are going to be appeals going up on these previous judgments.
Don, is there any interest in the questions that you are posing among members of the current General Assembly or state officials or the current head of the Department of Environmental Quality?
There certainly is interest down at the General Assembly. The question here is if we're going to have a regulatory scheme that is designed to prevent nuisance odors, why aren't we following it? And if we're not following it, maybe we ought to ignore to repeal it.
What is a nuisance odor, by the way? Because is there a certain, threshold of smell that has to be met?
Obviously, it's somewhat subjective, but the language that is used by the courts, in fact, is reflected in the rule. So in other words, whatever the courts think it is, that's what the rule describes it as. They use the same words. And it has to do with the interference of your enjoyment of your property, etc.
We know that the agriculture industry and the hog farming is vital to North Carolina's economy. But I got to tell you, if I'm someone who is currently involved in that industry or is thinking about getting involved in that industry, I have big-time questions over, will I be sued?
Well, this is exactly what you just brought up is exactly the reason that at that time Attorney General and later Governor Mike Easley worked so hard to develop this solution, because it was a burgeoning and very valuable industry to North Carolina. And I think to his credit, ultimately Governor Mike Easley put together this structure that had been working. And I'm somewhat concerned that perhaps trial lawyers, in an attempt to gain large punitive damages, may have ignored this.
You have to wonder if the former governor, Mike Easley, is following this and wondering what's going on, since he worked on this and apparently did a lot of work and came to what the industry and regulatory officials felt was a good solution.
It would be interesting to know. I do know Governor Easley has maintained a very keen interest in this industry, and so should all North Carolinians. It's that important.
So, Don, what should happen going forward? You said there are going to be more lawsuits, and currently we have some rulings that make sure that people are on the hook for millions of dollars unless those judgments are lowered on appeal. So what do we do?
2 things. I think we're going to be monitoring the cases as they go on through the district court level, and I know that some of the attorneys there are aware of this question, and hopefully if a judge the earlier judge ignored this, maybe the current judges will not. Similarly, in the appeals process, hopefully they'll take a look at this.